Ladies and gentlemen, good afternoon. I am sad that I cannot be with you in Brussels today on this important occasion when the European Shoah Legacy Institute presents its Holocaust Immovable Property Restitution Study on the day that it's being officially launched and presented before the European Parliament. I am the lead author of the study, a project that my study team and I have worked on for 2 years, beginning in the winter of 2014. The study, 1,265 pages long, presents reports on 47 countries, ranging from Albania to Uruguay, and covers the legal regimes involving post-Holocaust restitution in all the countries in Europe where Jewish property and property of other targeted groups was stolen. It also covers countries where the proceeds of such property ended up, including the United States and Israel. The resulting 47 country reports are the product of multi-layer research and involved 4 stages. In the first stage, and under our supervision, pro bono attorneys from leading international law firms conducted initial independent country research for each of the 47 countries. Stage 2 involved connecting with the Terezin Declaration countries and their governments directly. And during summer of 2015, all the Terezin countries received questionnaires and our preliminary research findings. Nearly half of the governments, 22 out of 47, responded to the questionnaires. For this stage, I especially acknowledge the invaluable assistance our team received from our distinguished moderator on this panel, Ambassador Jiří Sittler. In his role as Special Envoy for Holocaust issues for the Czech Republic, Ambassador Sittler spent literally hours on the phone with myself and Krista Nelson, our project research leader, and then with Ms. Nelson alone, discussing the finer points of Holocaust restitution legislation in the Czech Republic and how this restitution legal regime actually worked in the Czech Republic. Thank you, Ambassador Sittler, for being such a patient and a wonderful teacher. We really appreciate it. The study also benefited greatly from the input of Evan Hochberg, who is the Director of International Affairs at the World Jewish Restitution Organization, and Gideon Taylor, who is the Chair of Operations of the World Jewish Restitution Organization, with whom I have had the pleasure of working in the Holocaust restitution arena for the last 20 years. In the third stage, our 4-person legal research team conducted its own independent research to verify, synthesize, and analyze the information provided by the law firms and governments to create a comprehensive report for each of the 47 Terezin Declaration countries. As you will see when you examine the reports, the length of each country report varies depending on that country's connection to the Holocaust. For the European countries occupied by Nazi Germany, and especially those with a large pre-war Jewish population, such as Poland and the Baltic countries, the reports are more detailed than those countries that remain neutral during the war. Our report on Poland, for example, with the largest population of Jews in pre-war Europe of 3.3 million, came in at 50 single-spaced pages. Finally, in stage 4, independent scholars, legal experts, and historians active in the Holocaust restitution field for the country reviewed each of our major reports to assure accuracy and provided valuable input. Beginning this week, the study is now publicly available on the ESLI website, shoahlegacy.org. The reports for each country are easily searchable by clicking on the name of the country and the flag of the country. In addition to reports for each of the 47 countries, totaling, as I already mentioned to you, over 1,200 pages, the study also includes a 16-page executive summary, a 3-page overview, and the actual questionnaire responses we received from the 22 countries that responded. Now, a hard copy of the 3-page overview is included in your conference materials. With the online publication of the reports, we are now at stage 5. What this means is that if you disagree with any of the content or the accuracy of any of our reports, or have something to add, please, I urge you, drop me a line at my law school address, bazyler@chapman.edu. The study is a living document, and your input will be most welcome. If we look at the contents of the study, we first find, in the words of U.S. Ambassador Stuart Eisenstadt for Holocaust issues, that Holocaust restitution remains the unfinished business of World War II. For countries in Eastern Europe, there was little time to create successful restitution schemes before the communist regimes came to power in each country and collectivized and nationalized private property. As a consequence, for Eastern European countries, legislation from the 1990s and 2000s necessitated a more comprehensive approach, covering greater time periods and more property than is the case of Western Europe. However, Holocaust-era confiscated property is often specifically excluded from post-communist restitution legislation. By contrast, countries in Western Europe initiated restitution measures almost immediately after the end of World War II. The work of national commissions and subsequent legislation in the 1990s and 2000s in those countries was therefore mainly focused on restitution completion efforts, gap-filling measures of the measures that were first began in the 1940s and 1950s. Let me now go over a summary of each of the different types of property and what did the study found. First, with regard to private property, we find that some Eastern European states have substantially complied with the Terezin Declaration and the accompanying guidelines and best practices regarding restitution of private and movable property. Many have only partially complied, and Poland and Bosnia-Herzegovina have not complied. Many of the former communist states of Eastern Europe have made efforts to comply with the Terezin Declaration. There are, however, important areas where the laws of these states do not yet meet the standards of the Terezin Declaration. For example, Croatia, Lithuania, Macedonia, and Slovenia still limit eligible claimants to those who are citizens of their respective countries. Other former communist states of Eastern Europe have not yet fulfilled their Terezin Declaration obligations to enact immovable property legislation covering Holocaust-era property. Poland, with the largest Jewish population in pre-war Europe, of which 90% did not survive the war, is a prime example. Poland and Bosnia-Herzegovina stand alone as the only countries that have failed to establish a comprehensive private property restitution regime for property taken either during the Holocaust or communist eras, or one that addresses both types of takings. The study found that most Western European states have complied or substantially complied with the Terezin Declaration and the accompanying guidelines regarding restitution of private and movable property. Moving on now to communal property, the study found that some Eastern European countries have substantially complied with the Terezin Declaration, but many have only partially complied. For the former Eastern European states, with the onset of communism, both Jewish and non-Jewish communal property was either nationalized or never returned to the various ethnic and religious groups in whose hands it was held prior to the war. After the fall of the Iron Curtain, most former communist Eastern European countries passed laws to return communal property to the ethnic and religious communities from whom it had been taken. Only Bosnia-Herzegovina and Montenegro have failed to enact communal property restitution legislation covering either Holocaust-era confiscations or communist-era takings. Progress in some countries that even pass laws to return communal property has been very slow. For example, Poland, fewer half of the 5,500 Jewish communal property claims filed under a 1997 restitution law have yet to be adjudicated. In some countries, reconstituted Jewish organizations often were excluded from utilizing restitution laws because they came under different legal ownership than the pre-war Jewish community, or sought to reclaim communal property that was not used strictly for religious purposes, such as Jewish schools, hospitals, or community centers operated by various Jewish groups. Ownership over many formerly Jewish communal property in Latvia remains in dispute and are not subject to current restitution legislation. Croatia, where a restitution law was passed in the early 1990s, covered only communist-era property confiscations and excludes property that was taken during the Holocaust, and does not cover properties that were owned by different Jewish legal entities. The study found, on the other hand, that most Western European states have complied or substantially complied with the principles of the Terezin Declaration. Last category, heirless property. The study found that most European states, both Western Europe and Eastern Europe, have not complied with the Terezin Declaration. Some have only partially complied. Bosnia-Herzegovina, Bulgaria, Croatia, Czech Republic, Denmark, Estonia, Latvia, Lithuania, Luxembourg, Montenegro, Poland, and Slovenia have not enacted heirless property legislation. Of note are the Baltic states and Poland, which had the highest percentage of deaths in its Jewish population in German-occupied Europe, and correspondingly likely the largest percentage of heirless property due to the number of deaths. Austria, Belgium, France, Germany, Greece, Hungary, Italy, Macedonia, the Netherlands, Norway, Romania, Serbia, and Slovakia have all enacted heirless property legislation. Yet, a list of enacting countries fails to capture whether a country has actually fulfilled the letter and the spirit of the Terezin Declaration. For example, while Romania has an heirless property law in its books, the law was never meaningfully implemented. A large obstacle is that under the domestic law of most European countries, both Western and Eastern, heirless property reverts to the state. The Terezin Declaration, recognizing the uniqueness of the Holocaust and the unprecedented scale of heirless property left following the mass murder of millions of people, recommends that heirless property should be allocated for the benefit of needy Holocaust survivors, for the commemoration of destroyed Jewish communities, and Holocaust education, rather than simply as cheating to the state. Unfortunately, this has not been implemented. Let me now end. In conclusion, the Nazis and their state-sponsored partners stole mercilessly from the Jews of Europe. Returning victims with no more than clothes on their backs had to navigate a frequently unclear path to recover the property from their governments and neighbors who had failed to protect them, and often who had been complicit in their persecution. Many survivors embarked on their restitution journey not knowing whether they would ever be successful. Many others never knew that recovering property was even an option. Law was not the survivors' ally. More often, it was their enemy, providing immunity and impunity for those who wrongfully took or benefited from Jewish stolen property. The commitments that 47 countries made in June 2009 in the Terezin Declaration, 64 years after the war ended, and on the site of the Terezin concentration camp in the Czech Republic, where 33,000 Jews perished and another 140,000 were transported to their death camps in German-occupied Poland, aimed to bring a measure of long overdue justice to victims and their heirs. However, over 70 years after the Holocaust, a substantial amount of immovable property confiscated from European Jews remains unrestituted. While there have been significant steps forward in a number of endorsing countries, in the post-communist countries of Eastern Europe, there remains much to do regarding return of private and communal property. Thank you.